Don't forget, you can reach the latest episode of Potomac Watch anytime. Just ask your smart speaker, play the Opinion Potomac Watch podcast.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. Let's turn to a final set of rulings in two cases, Moody v. NetChoice and NetChoice v. Paxton. This involves laws passed in Texas and Florida to regulate social media companies. Alicia, what's your read of what the Supreme Court did here?
So in some ways, the Supreme Court punted these cases because it actually didn't rule on the merits. In both cases, I'll just back up a little bit. The Texas and Florida passed laws that seek to prevent social media platforms from silencing conservatives. So that was the goal, and apply it to silencing liberals, I suppose, too, if the platforms were to do that. The Florida law banned social media platforms from removing political candidates or posts about them. Platforms also weren't allowed to censor journalistic enterprises like the Wall Street Journal, but some also small blogs. And they were required to apply their standards in a quote-unquote consistent manner. The Texas law in some ways was broader, but also in some ways it was narrower. It prevented platforms from making any kinds of editorial decisions based on the viewpoint of a user's expression, and included a bunch of other disclosure requirements for platforms to tell users why their posts were removed or why they were booted from the platforms. Now, NetChoice, which is an industry group representing a lot of the big tech companies, but also some smaller ones, challenged both the laws, saying that they violated their First Amendment rights and infringed on their speech rights. And what the Supreme Court said, well, you mounted a facial challenge to all aspects of the law. The Fifth Circuit actually upheld the Texas law while the 11th Circuit struck down the Florida law. But at oral arguments, there were a lot of things that just weren't clear in the case record. For instance, who would actually be covered by these laws? In Florida, during the oral arguments, for the first time, it was brought to, well, maybe Uber and eBay and Etsy could actually be covered by these laws. And the constitutional implications for them are very different than the Facebook or YouTubes and such. And so what the Supreme Court said, it tossed it back to lower courts and said, you need to consider the applications for different kinds of platforms. What they also said was, NetChoice, you shouldn't have brought a facial challenge. And what I mean by facial challenge, you shouldn't have argued that these laws are unconstitutional in all the respects as applied to everyone. In addition, there's a majority of the court also strongly suggested that the Texas law, or in the Fifth Circuit, was wrong and the Texas law is likely unconstitutional. It didn't really opine on the Florida law, however.
But it seems there's little doubt that these cases will be back, Kim, after some more percolating in the lower courts. And so it is interesting to see the justices jockeying a little bit in anticipation of that future case. There's a concurrence by Justice Alito, joined by Justices Thomas and Neil Gorsuch, taking a more skeptical view, suggesting that maybe these laws will prove to be okay. But I suppose nothing is final until we get to that future case and get a final ruling on it.
Yeah, I think the thing I liked most about that opinion that Alito and Thomas and Gorsuch were on were simply their warning, which I think really should be viewed with great seriousness, that this is a big issue that could have some very, very sweeping consequences. And so tread carefully, because you could end up with an opinion here, one that the lower courts come up with that the Supreme Court allows to let stand, or one that the Supreme Court weighs in, that could end up coming back to haunt people and the court down the road, because this is uncharted territory. Social media companies, their interactions with constitutional First Amendment issues, moderation, states' involvement in that. Where are the limits of that involvement? What are the contours? How far does this extend to which different companies? Do we make distinctions between different tech companies? Or is there some way to say this is what a social media company is and only they fall within that circle that we're talking about? Really huge questions that we have not done a lot on, and Congress also hasn't said a great deal on either. In fact, this is why we've got some of these problems, is because Congress still doesn't know how to handle some of the problems and questions presented by social media when it comes to legal questions and policy questions. So their argument, tread carefully, because a bad decision could have some very sweeping consequences and come back and cause some agony for the court down the road.
Thank you, Kim and Alicia. Thank you all for listening. You can email us at pwpodcast@wsj.com. If you like the show, please hit that subscribe button, and we'll be back tomorrow with another edition of Potomac Watch.